It is my pleasure to welcome a returning guest back to the show, and that is my good friend Mauricio Rauld. And he is founder of Premier Law Group. He is a syndication attorney, and he is deep into the world of real estate. He's all about real estate. And he thought of an interesting topic that I think you'll really like, which is I'll throw out some various asset protection vehicles, and Mauricio's going to poke some holes in them. You know, you hear a lot of these people out there with their hype and sensationalism about be bulletproof asset protection. This is the strategy you need. Folks, nothing is bulletproof. Everything has weaknesses. You know, you've all heard the old saying, a chain is only as strong as its weakest link. And that is definitely true. But I will tell you that if you are not thinking about these topics and you are not setting up entities and strategies for yourself, you are making a huge mistake. This is the one thing in life that is really inexpensive to do. It's quite easy to do, but you must do it in advance. You must do it in advance. That is the one area that you cannot fail. You can't be late to the party on this. It's got to be in advance. So Mauricio's nodding his head a lot. So without further ado, welcome. How you doing?
Thanks, buddy. Good to see you again. Always great to be on the podcast.
Likewise. So LLCs, maybe we'll just start there.
Let's do it.
Of course, there are 50 states. According to Obama, there are 57 states. We won't debate that right now, but
are there more states or more genders? What's going on?
No, I think there's like 64 of those actually. So, you know, look, you can't just talk about an LLC generically, right? Because of course, every jurisdiction has different laws. And if you're using the LLC from one state and domesticating it or registering it or whatever the right terminology is in another state, then the rules may change.
Yeah.
Okay. So there are complexities to all of this stuff. So talk to us about LLCs. Are they bulletproof?
No, they're definitely not bulletproof, but they're definitely better than nothing, right? So this is all about having layers of protection, right? And so I talk a lot about that in the book. But first of all, just think of LLCs as a backstop. Like your first line of defense is got to be insurance. Like as much as I hate the insurance world and I've got my pet peeves and they've got a ton of issues, so we can I definitely want to talk about the holes in insurance policies. But in the event insurance doesn't cover you for whatever reason, or you're underinsured or whatever, you want to make sure you have a backstop to protect you for the next level. And that's where LLCs, limited liability companies, come into place. The beauty of LLCs is that they will limit your liability, meaning whatever happens if you own a property, for example, in a limited liability company, and somebody slips and falls on your property, or maybe a boiler explodes, some injury happens, the owner should be responsible, which is the LLC, and that should generally limit your exposure to just what's inside of that LLC. The challenge, I think, where people are where the thing starts to fall apart a little bit is you do have all these promoters that, you know, say, hey, look, you should set this up in Nevada or Wyoming or all these great states. And those are premium asset protection states. Just so we get it out of the way, I consider Wyoming, Nevada, Delaware, and now Texas, by the way, as of September of last year, Texas has joined the ranks of sort of premium asset protection states.
There are many that are good and bad for different reasons, but you know, one that people don't commonly think of that I hear is pretty good is Alaska.
Yeah, but Alaska's great for trusts, and that's sort of a more advanced strategy. Like if you get an asset protection trust, I believe Alaska was one of the first, if not the first state to come up with a trust, but I think other states are better just because they have shorter statute limitations, which is beneficial. But the reason that, let me just backtrack a bit. The type of LLC will dictate where you set up these entities. So if you have a property in Dallas, Texas, for example, right? And you create an LLC in some other state, like in Nevada, and then you have to then register the company back into Texas, it really doesn't matter, because if somebody slips and falls on your property in Texas, Texas law is going to apply. There's nothing you can do about it. If you live in California, which I know you used to do, and you used to love living in California, down here in San Diego, I remember. You know,
don't put words in my mouth. I didn't love California.
You told me it was the greatest state that you've ever lived in.
Kidding me? I didn't say that.
Just kidding. You know, if something happens in a state, you get into a car accident in California, you have a slip and fall on your property in California, I don't care where you set up that entity, California law is going to apply. And so there's really no benefit of setting these things up anywhere else. However, when it comes to actually owning other assets, meaning what we call holding companies, right? They don't really do anything. They just own other LLCs that in turn own other assets. because they're not doing business, they're just literally sitting there holding membership interests in another LLC. That's where setting these up in other states like the Nevadas and the Wyomings and the Delawares of the world starts to make sense, because they have something called charging order protection, meaning if something were to happen to you, Jason, unrelated to your assets, got nothing to do with your properties or your businesses, you got into a car accident or you got into a business dispute or something happened, there's a judgment against you. Now I want to know what you own. It is beneficial to say, hey, I don't own any of this stuff. I just own a Wyoming LLC or a couple of Wyoming LLCs, because I'll have access to what's called the charging order protection, which is really, when it comes to LLCs, is the number one protection, which is going to limit me, who has sued you, is going to limit me to your distributions of whatever, whatever distributions you were getting. Those will come to me now because you have a judgment, but I can't get ownership of your LLC. I can't get control of your LLCs. And so that's really where the benefit of LLCs comes into, is this charging order.
Let me help make some distinctions here. Okay. One of the huge mistakes that people make in trying to understand and navigate the world of setting up estate planning and entities to protect assets and so forth is they fail to understand the difference between the internal threat and the external threat. They seem to only think about the internal threat. Correct. That example is a cliche. Oh, you have a property, it's owned in an LLC, the tenant slips and falls on a banana peel and they sue you. That's just so rare. It's easy to insure around. That's not the problem. But what could happen that can be more devastating is an outside thing occurs. It's an external threat that occurs from some other part of your life. And then they look for your assets and they think, oh, you own this property, right? There's equity in it. We're going to try and take the property. And so what happens here, folks, is that in states like the Socialist Republic of California, that are not good states to do business in, and many others, they can foreclose on the assets of the LLC. And most of this, when I say LLC, probably, but you correct me here if I'm wrong, probably is almost synonymous with corporation. So if it's a corporation, or at least a closely held corporation, it's mostly going to be the same scenario, probably, right?
Let's talk about that, because there's an important distinction, but where you're going is exactly right. So finish up your point, because you're doing a great job of explaining it.
And I'm not a lawyer, okay? I gotta say that. And I'm not a tax advisor. But you don't want them to foreclose on the assets of the entity, okay? What you want, you don't want any of this, okay? But if you're going through it, you want them to have the sole remedy of obtaining a charging order from the court. And that charging order is basically kind of like this. They say, okay, look, Mauricio owns this LLC in Wyoming or Nevada or Delaware, or now Texas, you say is also very good. Mm-hmm. We're going to go knock at the door of that LLC and ask it for money. And as long as no money leaves the door of that LLC, they can't get it. They have to just wait by the door indefinitely to collect. So in other words, if you don't take a distribution, they can't do anything except sit there and wait, right?
That's a beautiful analogy. It's one of the best ways I've heard explain it. Like literally because I talk about the distributions and the liens, but that's really a good analogy. Like you literally, if there's money flowing out of your LLC through this door, then that's going to go to the creditor because you owe them a bunch of money, but you still have control of the LLC. You still have ownership of the LLC. So you can close that door and lock the door and throw away the key. And now no money is flowing out of that LLC, and therefore no money is going to your creditor, which is a key thing. And the reason—
So one question about that before you move on. What if you take a salary out of the LLC? Can you do that?
Yeah, so there's other creative ways, because obviously you can't take a distribution either, and so there's other creative ways for you to extract that. You can take a loan against the company, right? You can take a salary. You can have a management company that you create and become the manager, and get the manager, have a manager fee. So there are other ways, creative ways that you can extract, which is why nobody who's suing you, certainly not plaintiffs' lawyers, let's talk about that for a second. Plaintiffs' lawyers, the last thing they want is charging orders. They want to foreclose, to your point, like in California. They want to be able to say, Judge, forget this charging order nonsense. I don't want that. I want you to order Jason to hand over his shares in the LLC. So now I own them and I can do whatever I want with them, which is going to be really to liquidate whatever the assets are in and get paid. And so in states like California, this is why California why Georgia, why some of these other states are terrible, because the charging order is not the exclusive remedy that's available. That's one of many. Other remedies include foreclosure or just flat out a turnover. I don't even have to foreclose. I can just go to the judge. The judge, just give me his shares because he owes me a bunch of money. So I want half of the company or all of the company. And they just hand it over. So you want to be in a state where charging order is the exclusive remedy. That's why that's the important language. Is the charging order protection the exclusive remedy available for a creditor that's coming after you? And if the answer is yes, that's a good state to be in. And about half of the states, by the way, have that charging order as the exclusive remedy. The reason why Nevada, Wyoming, Delaware, and now Texas are really even next level is because they're the only states where charging order protection, the exclusivity of charging order protection, extends to single member LLCs.
Right.
So if you have an LLC and it's just you, or you and your spouse, by the way, you and your spouse is generally considered one, then in most other states, they don't use the charging order protection is meant there to protect your partner. So if you don't have a partner, then it doesn't really make any sense. But those states have run, those lawmakers have gone and amended their laws, amended their statutes to include and say, look, if you're a single member LLC, Jason, if you're the only owner here, you're going to have the same protection, the same charging order protection as a multi-member LLC.
Yeah. So to be fair then to California and the other bad states, right? To be fair, if you have multiple members, then you have that same protection.
You don't know, because in California, a charging order is not the exclusive remedy available. So the judge has the right. It says they may get a charging order, but they can also foreclose. It's up to the judge.
Yeah, but not if you have a partner. They can't foreclose on your partner's assets, right?
No, they don't. But what they'll do is just imagine you and I are business partners, right? Jason, you got into a car accident, nothing to do with our business. There's a bazillion-dollar judgment. The judge gives 50% of the company to you, to the creditor. Now I'm stuck with a freaking creditor as my partner. I want to run the business. I want to grow the business. And now I'm stuck with some guy or gal who all they want to do is liquidate and make my life miserable and just get out of there. That's why the charging order exists. It's not really for your protection, honestly. It's for the protection of your partner, who it's just not a good public policy to put a real business person and a creditor to now run the business. And imagine if you had a majority.
Well, that's why I thought even in the negative, undesirable states, I thought they did give you that same protection as long as you had a multiple member scenario.
One of the protections. It's one of the remedies available. And again, California, the judge may say, look, the way this is going to set up, I'm going to give you a charging order because there's multiple and it's going to hurt the other party. But it's not the exclusive remedy. You're looking for that language in the statute that says whether the charging order is the exclusive remedy or is the charging order, the judge may give a charging order.
Right.
So that's an important distinction. And like I said, about half of the states have exclusivity.
Okay.
But only those 4 have exclusivity for single members as well. And like most of us at some level, even if you run a huge business, at some level, your holding company, your ultimate, top of the chart, it's just going to be most likely you or your living trust or you and your spouse. It's going to own your personal sort of holding company. And so it's very important to have those charging order protections.
Okay.
But again,
so you wanted to make the distinction between a corporation and an LLC.
Yes, let's do that, because corporations do not have charging order protection. So if you own a corporation, there is no charging order. They'll just hand over the shares. I can go to the judge and say, hey, Jason owns 10,000 shares of this company. He owes me $1 million. Judge, please hand those shares to me. There is no charging order protection on corporations except for the state of Nevada. The state of Nevada is the only state of the union that does extend charging order protections to shares in a corporation. Everybody else you do not have, which is why LLCs are generally considered a superior asset protection entity over corporations. Corporations are more to run your businesses and have shareholders and all that kind of stuff. But from an asset protection standpoint, corporations are terrible, which is one of the reasons I don't like S corps. For example, if somebody wants to set up an S corp, I talk about that in one of my legal strategies to avoid. And I've talked to all the CPAs as well. S corps, first of all, they don't even exist. They're just corporations that have elected to do an S election to do the pass through. You can do that with an LLC. You can have an LLC and have it taxed as an S corp, and that's a much preferable because you get that LLC structure, which gives you that protection.
Now, Baselane, our sponsor. It is the #1 banking platform built for real estate investors. It's banking, online rent collection, bookkeeping, tax reporting, analytics, and more. You can enjoy real-time cash flow analytics on your properties. You can get ready for tax season with automated bookkeeping and financial statements ready for your CPA. Join more than 40,000 real estate investors who trust Baselane to manage their rental property finances. Go to baselane.com/Jason for a chance to win a $500 Amazon gift card. Yeah. So I think, though, you need to distinguish here, Mauricio, between the internal and the external threat.
Yes.
So in that example of the corporation that does not enjoy charging order protection, that scenario you outlined is only for a situation where the threat was external.
Correct.
If the corporation itself has a judgment against it,
100%. Yes, that has limited liability. Yes.
Right?
So yes, I should have. I love the fact that you did
even
that,
on a single member or a single shareholder.
Yeah. So there's, like you said, there's two angles to it. There's the inside attack, outside attack. I like to sometimes say you want to protect you from your assets and also your assets from you, because people always think of it as just, hey, how do I protect myself if somebody attacks my asset? And I'm like, wait a minute, you're probably more of a liability producing machine than all of your assets combined. You're out there doing business every day. You're driving your car. You're doing all that stuff. So what happens if you get sued, regardless of your assets? And that's where the outside attack comes in. So anytime you hear the word charging order, I want you to remember it only applies to outside attacks. That's when you say charging order, we're talking about outside attacks. When we're talking about inside attacks, I like to use more the word like it's the limitation of liability really is what we're looking at, because your liability is limited to what's inside the corporation or inside the LLC. But yes, if you own a business in a corporation and the corporation gets sued, the corporation is a separate entity from you, and unless there's some mechanism to pierce that corporate veil, they should not be able to get to you personally, because you're acting as a separate company, a separate entity.
Okay, very interesting. All right, what do you want to do next? You want to talk about trust?
Yeah, I mean, at some point, the LLC, the challenge with the LLC is that there is still an ultimate owner. So you have this concern. There's a couple of concerns with LLCs. The holes of an LLC is that a judge can always try and, everybody tries to pierce that corporate veil. So again, you have a home, something happens in the home, so the LLC is responsible, but I want to get to the owner. There are mechanisms where I can try and convince a judge to kind of ignore that protection and what's called pierce the corporate veil. And especially if you're a single member, it's not the hardest thing to do, because people sometimes just don't treat them as separate companies. They start commingling their accounts. They don't respect the corporate formalities. They just kind of treat it all as one. And if you start doing that, it gets easier and easier for somebody to pierce that corporate veil and get to you. So that's one concern. And then, of course, the other concern is again, if you're in California, for example, and you're in and you have really liberal judges, even though you may have a Nevada entity or a Wyoming entity, it's not beyond the judge to say, you know what, I know that your LLC is in Wyoming, but I'm going to apply California law anyway, and I'm going to go hand over these shares, which has happened before. So there are limitations to LLCs. And so the next layer of that is really to remove you completely from that ownership. And that's where trusts come into play. And when I say trust, I specifically mean irrevocable trusts, which are what we call asset protection trust. Well, I'm not talking about your living trust. One of the biggest mistakes people make, the biggest misconception, is that your living trust has some sort of asset protection value. It does not. Your living trust provides zero, zilch, nada, zero asset protection. Living trusts are for estate planning purposes. It avoids probate, other things.
I think everybody gets that.
Yeah, but you'll be surprised. But an asset protection,
my listeners get it. Yeah.
An asset protection trust literally removes the ownership, so that the LLC, so think about the structure. You have a property that's owned by an LLC. The LLC is owned by a trust. Nobody owns a trust. There is no owner of a trust. You only have beneficiaries of a trust and trustees of a trust. So it eliminates that problem of piercing the corporate veil, and you literally do not own that asset. The ownership has been completely removed from the chain of title. And because we live in a jurisdiction where everything is based on chain of title, that's the benefit of a trust. Now, it does have some holes in it, because the judges still have to have control over you, right? So if somebody's trying to sue you and the judge really wants to get to your assets, they may not have control over the asset, they may not have control over the trust, but they have control over you, and they can demand and say, look, if you don't transfer this out of this thing, or don't do this or don't do that, we can hold you in contempt of court and throw you into jail. And some of the most famous cases around asset protection trusts involve those scenarios where the judge said, hey, hand this over. They refused or said they tried to, and they ended up spending a year in jail before convincing the judge.
By the way, I just want to make a point about this, because there's this mistaken theory people operate under, and that theory is judges have to follow the law. And in theory, they do. But they can always pull this contempt thing out of their back pocket and do whatever the they want.
Yep.
It's really scary. And they don't even have to follow the law either, because we've all heard about and read about activist judges and so forth that just make these nutso crazy rulings, right? Literally, you can show them the case law, you can show them the statutes, you can show them everything. And one of the things that has really surprised me about the legal system is that judges don't even read the documents. Right. Sometimes they delegate it to their clerk.
Oh, 100%.
Who's a kid. Like, they're a kid. Okay. It's some kid in their early 20s.
Right out of law school.
Or maybe going to law school. I don't even know.
Maybe even clerk and jury clerk. Yeah. They're clerks.
And it's totally shocking. Who knows if they're even reading anything? So they'll rule on things without reading it. They'll disobey the law, and they'll use contempt as a way to just legislate
bypass. Bypass.
Because
because one of the theories, obviously at some point when you create a trust, you end up transferring your assets from wherever it is now and putting them inside the trust, as you know. And so there's always the argument, well, that was a fraudulent transfer. The only reason you did that was to avoid creditors. And so if a judge wants to go down that route, they can say, Jason, I want you to transfer that outside of I can't control the trust, or I can't transfer that asset back into the LLC or back to where I can now have control. And if you say I can't, or I don't want to, or whatever, to your point, they can hold you in contempt of court and can throw you in jail to comply. Now, at some point, when you spend too much time in jail, there becomes a point where, okay, he must be telling the truth, because nobody wants to spend a year in jail. So he must be, and then they let him out. But the famous cases
that'll ruin your life. I mean, you're waiting out the judge, right?
Yeah.
So,
but I want one important point, Jason.
Basically, folks, I mean, this is welcome to North Korea. That's pretty much what you've got with some of the stuff these judges can do. They're insanely powerful. So it's pretty scary.
Before I went to law school, I actually went to work for a pretty well-known plaintiff's lawyer up in the San Francisco Bay Area. And as you know, plaintiffs lawyers, right, people who are actually going to file lawsuits against you, they work on a contingency fee basis, right? So they only get paid if they're able to recover damages on behalf of their clients. And so the plaintiff's lawyer have a huge incentive to make sure that if they go spend the time, little years, to go get a judgment against you, that there's something to collect on the other side of that judgment. And so one of the first things we used to do, and what plaintiffs lawyers generally do, is they do asset searches, right? They'll pull, it's very easy to do a property search. They can find out, hey, what properties does Jason own? I can do a bank sweep to see what bank accounts Jason owns, or what brokerage accounts Jason owns. And if they can't find anything, right, that's where the privacy and putting things in trust and LLCs and kind of removing ownership. If they can't find anything, then the plaintiff's lawyer is much less inclined to go pursue that, because they don't want to go spend 3 years, get a judgment, and then be like, okay, let's collect, and there's nothing there. So having an insurance policy at that point, they tend to just want to settle for insurance policies. And so privacy is a big point of this, because what people forget, or not that they forget, they don't really realize, is that your ability to pay the judgment is completely irrelevant during the lawsuit. They can't ask you about what you own or where you have it, or do you own a trust, or where you're. None of that is relevant as to whether you are liable for a particular claim. It's only until you get a judgment against someone that you can then start bringing them in for depositions and and asking them all the stuff. But a plaintiff's lawyer doesn't want to go spend 3 years of their life getting a judgment, no matter how strong the case is, if they don't have some level of assurance they're going to be able to collect. And so having trusts and having LLCs, if your excess cash is in an LLC as opposed to your personal name, they won't be able to find that. And the odds of them suing you decline significantly. And the odds of them taking a settlement for the insurance limits goes up exponentially.
But they will be able to find it if you're doing business with it. That's why you need holding companies.
If they can see somehow, it's going to have to be a public transaction, right? And if you're doing business,
what I mean is if they know that's your business, they're going to know. Yeah.
And that's what we talked about it earlier. I mean, your businesses, which are your operational companies, that's where all the liability is anyway. Those companies shouldn't own anything, right? You should have a little bit of money in a bank account, but your valuable assets should be tucked away in a holding company in one of these states that we like, so that they're really private. Nobody should know. It's nobody's business that you have 100 rental property somewhere, or you have a bank account with $1 million. Like, that's none of anybody's business. You should have all of that stuff in a private LLC or a trust or something like that, so that people can't just go and do a public search and follow, because otherwise you just have a big target on your back, right?
All right. Yeah, no question about it. Okay, so Mauricio, we've got to get back to this question of trust, okay, because we got to poke the holes in that, right? So you've got a trust that's not a living trust. It's a trust that's meant for estate planning, asset protection. And the amazing thing about these trusts is some of these things have been around for 1,000 years. It's incredible that these old European families have passed down assets through many generations. And this is the one way to really leave a legacy, folks, because these trusts, they're so durable. It's amazing. I mean, can you imagine having your future generations 1,000 years from now? I mean, like that are engaging with this trust that you set up. That's an incredible thing. The year is 3,122, right? Or some whatever, right?
Yeah.
And you set up this trust, and it's still there.
Yeah, you pass the beneficiaries down to generations and generations. I mean, you can set it up. I mean, just ask the Rockefellers, right? You set up the thing, and it's like, hey, I'm going to hand this much to this generation, and then next generation, and you kind of pass it down. And as long as they're good stewards of the money, it can last forever. I mean, the big holes. And the first one's not really a huge hole, but one is obviously a cost factor. I mean, if they were handing, I always say, if people are handing out asset protection trusts for free, then I think everybody should have one. It just has an exponential cost, especially if you really go offshore, which is really where really the gold standard of asset protection is offshore trusts. But the whole for an offshore trust is what we just talked about. Like, even though you may set it up, let's take the Cook Islands, for example, which is parenthetically where I met my wife. But the Cook Islands is the gold standard for a trust. If you're looking to set an offshore asset protection trust, it doesn't get any better than the Cook Islands. It's virtually impossible to go break that trust, go fly down to the Cook Islands, and breaking that trust, getting assets from that trust is virtually impossible. However, as we mentioned earlier, if you're here in the United States and there's a judgment here in the United States and you're in front of a U.S. judge, the U.S. judge has jurisdiction over you and can basically order you to bring those assets that are offshore, bring them back to the United States. And if you decide that you can't, because that's going to be the main thing, you're going to write a letter to your trustee asking them to comply with the judge's order, and the trustee is going to decline because that's what they're supposed to do. So you're going to come back and say, Judge, I try to get this. I try to comply with your order, Judge. I try to get the trustee to wire money over or sell assets to bring it back, but they won't listen to me. I don't have any control. But the judge does have that. If they don't believe you, they have the opportunity to hold you in contempt of court and throw you in jail, which again has happened.
So what are they holding you in contempt for? They're saying you're lying? Is that the contempt?
Yeah, they don't believe you. Yeah, you're just like, hey, I'm ordering you, Jason, to call your trustee and demand that money gets sent back. And you're going to send them a letter. Look, Judge, I already sent them the letter. I requested it I demanded it, and they declined because they have to, because that's in the trust documents. And so you did not comply with the judge's order. And if they don't believe you, they have the power to throw you in jail, which has happened at least a couple times on some very well-known cases.
Right. No, I remember reading one of those in the Wall Street Journal many years ago. But, I got to ask you, Mauricio, some big businesses, and I can't remember which ones, some big businesses are not corporations, they're trusts. Big businesses we all know of. I just can't remember the names of them at the moment, but they're business trusts. Now, is there some difference between a business trust and like the asset protection trust?
Yeah, I mean, like let's talk about REITs. I mean, a REIT is a trust, right? It's a real estate investment trust, right? So that's a good example too. Yeah, no, it's got to do with specific language that you put we call it spendthrift language that we put into the trust agreement, which basically limits what happens with these trusts is that it's not like you're getting a distribution that just is consistent. Like a REIT is like automatically you're getting 90% of the distribution or whatever. So if I attack that, I'm going to get that. But it's the way that these documents are drafted that prevents somebody from automatically being able to pull that money. It really does depend on the trustee. And of course, the trustee is somewhere off in the Cook Islands or some other trust. So you have no jurisdiction over the trustee. Now, again, the other argument I like to make too is like, if you really are well off, I mean, you always have the option to just leave the United States. If it really gets to that point where you're about to lose everything and you don't want to go there, if you do leave the U.S., then there's zero jurisdiction over your offshore trust and stuff. But yeah, so it does have to do with the just because it's an irrevocable trust doesn't necessarily mean it's not all irrevocable trusts or asset protection trusts. All asset protection trusts are irrevocable.
Right. So if you look at the only one I can actually think of besides the REITs is Bitcoin's all the rage now, right? So the grayscale Bitcoin trust.
Yeah, like ETFs, exchange traded. Well, those are funds I get. Yeah.
I think Walmart might be a trust too, possibly. why would a business set themselves up as a trust and not a corporation, a big business?
Yeah, I don't know, Jay. I'm not gonna spec. I don't know the answer to that. I mean, certainly doesn't make any sense for us small potatoes to do that. Now, again, there might be, but even like a Berkshire Hathaway, obviously they're a corporation and they're a C corp, and but there's got to be some
All right. So let's
benefit. But I
get
don't
one
know.
other distinction here if we can. So a trust does not have a corporate veil like an LLC or a corporation, right?
That's exactly right, because you have removed that. Nobody owns the trust. The trust is its own separate, distinct person or entity or structure. It's got nothing to do with you because there is no owner. So you can't pierce the corporate veil to get to an owner because there is no owner. It only has beneficiaries, which are not owners. They're just the ones that get all the benefits from the trust. So that's one of the benefits of having, one of the big benefits of having a trust is you do remove ownership completely and you don't have that concern. You also don't have the concern of a charging order. Because if you get same thing, you look at the outside attack, right, and you get into a car accident or something completely unrelated, and there's a judgment against you, and I come to you and say, "What do you own?" You don't own anything. You don't even own the trust. You know, you're the beneficiary of the trust, but you don't own the trust. And so
poke the holes then. What's the hole? That sounds good, but
the hole is that if the judge wants to get to you, which they do, because you transfer the assets a little too late, or they think you're doing this primarily to avoid and hinder creditors being able to get to you. They still have control over you and they have power over you. It's not easy. I'm just saying there are holes. It's not bulletproof, right? There are holes, and there have been cases before, like the ones you probably read in the Wall Street Journal, the Anderson case and the Lawrence case, which is talked about in the book. They ended up in jail because the judge thought that they had just set up all these structures. A lot of times it set up structures kind of late.
I wonder what the real outcome was of that, though. Are they still?
They get at some point. Yeah, they get released. No, at some point. Well, I think one of them
did they give in
caving.
And somehow get the money out of the trust, or what? Like what happened?
One ended up caving, was able to repatriate some of the cash, and was good enough for the judge. And then the other one, at some point, when you spend 6 months in jail, at some point the judge has to go, okay, he's got to be telling nobody's going to spend 6 months or a year in jail just to do. I mean, that he truly must not have the ability to do that. And that's what happened in the other case where the judge at some point has to, but it's a year. Do you want to spend a year in jail in order to do that?
Okay. So the other part of it is that the trusts are expensive, right?
Yes, that's 100%.
How much, why are they expensive?
Well, first of all, there's two expenses. One is the creation of the stuff. I mean, I think a Cook Islands trust, you know, if you go to somebody who's competent, again, I don't set these up. I don't have a dog in this fight, but the ones that I've seen, I don't have an offshore trust, but I know they're about $30,000 to set up. And then there's an ongoing maintenance cost because you don't want to hire a U.S. trustee. So you're going to hire, let's say you set up a trust in the Cook Islands, you're going to want to have a Cook Islands trustee, right, to be the trustee and make all the decisions for you. And that's going to cost you another, $5,000 a year or something just to have the trustee. So they are expensive to set up. And so again, if you just bought your first rental property and have a W-2 job, you're not going to be getting a trust, let alone an offshore trust. But if you're Donald Trump or you're somebody who has significant assets, then having a trust is something that, again, it's the gold standard. It's as good as it gets. So it's something you should consider depending on how liable, what job you have. Are you a heart surgeon? Is your liability pretty high? And the size of your estate. I mean, if your estate is a couple $1 million or higher, spending 30 grand to do this protection makes a ton of sense. But if your estate, if all you own is a couple $100 grand, it makes no sense.
I'm puzzled as to why it's 30 grand. Like, for what reason is it that expensive? Just because lawyers can get away with it?
Well, maybe. I mean, you're also, and again, I don't set them up, but obviously, if I'm setting something up in the Cook Islands, I got to make sure it's compliant with Cook Island laws. I got to know Cook Islands law. There's not that many people who know how to do it. It's kind of supply and demand to do it well. So, can you get it for cheaper? Sure, I can probably find somebody in the Cook Islands to do it for me. But do you really want to have somebody out there do it for you, or do you want somebody licensed in the U.S.?
And then there's ongoing fees for maintenance, right?
Yeah, there's filing fees, but the big one's a trustee, because again, the trustee is not going to be the local cab driver, who's going to be your trustee, because they have control over all. You want to have it's going to be an institutional trustee that's bonded, insured, that your little puny $10 million is nothing to them because they've got $1 billion of trustees that they're overseeing. So yeah, it just becomes expensive on that side. So it's not for everyone. But I said if they were giving them away for free, everybody should get one because it is the gold standard of asset protection.
Right. Mauricio, the great thing about this interview, folks, is we go deep. Like, these are deep answers that Mauricio is giving you, folks. I hope you appreciate it. Most podcasts you listen to or YouTube video you watch, it'd be this like shallow discussion and call me at 1-800-lawyer, to pay 30 grand. Mauricio's really.
I don't do it. I don't have a dog in this fight. I'm a former recovering asset protection attorney, but I don't do it anymore. So it's one of the fun things for me is I can just get to tell you how it is and here are the pros, here are the cons, and you can make a good business decision of what works for you.
That's great. You know what's always I've always wondered, and you just alluded to it. These trustees, if you have a trust, and I have searched this before, but I didn't really find anything. Like, aren't there cases of trustees ripping people off and stealing money, embezzling money from a trust?
100%. That's why I say you don't, people like, for example, I used to, as you know, Jason, I used to live in Belize. And so Belize trusts are, not as good as that and not as good as the Cook Islands, but they're up there. And yeah, you don't want to have some Belizean taxi driver or bike guy be your trustee or your Uncle Bob, because there's an incentive for them. If they're overseeing $10 million, $100 million, even a couple $1 million, they have the ability to write a check and move money around. I mean, forget it. So you want to have somebody that's licensed, that's bonded, that has insurance, so that if the guy somehow takes off with their money, that the company has insurance to cover your loss, because they have absolute control. They are the trustee. They are the ones that actually make the decisions as to what to do. Now, just a little bit of a very technical thing. Most trusts are what we call dormant trusts. So they are coupled with an LLC. So the trust will own the LLC and you get to manage the LLC. So I wouldn't even have a bank account for the trust. I'd have a bank account, for the LLC, and I would run everything at the LLC level, but the owner will be the trust. And then there is no owner above that. That's how I keep control.
Yeah, right. But I would assume they could somehow get access to the LLC. They could go to that bank and say, hey, I'm the trustee, or I don't know, maybe not.
They could, because they obviously are the owner, so they could fire you as the manager, right? They could fire you as the manager and then insert themselves or somebody else as the manager that they control, and now the manager can go in and move money around. So yeah, to that point, they could still do that. So yeah, that's
the bottom line is, if you want to do all this stuff, there are some risks. So I think the answer is diversify. Don't ever put all your eggs in one basket. Okay. You can have multiple entities in multiple jurisdictions, and that's probably the wise thing to do. But the important thing also to do is to do something, because if you don't do this stuff in advance, folks, you're asking for trouble. I was reading an article a while back that said the average person, and I thought this was crazy. I thought it was ridiculous. I thought, no way. But then I thought about it and I thought, well, yes way. They said the average person in the US during their lifetime, they'll have 7 lawsuits. And I thought, gosh, I know people that never even had 1 lawsuit. But then I thought about it and I thought, well, if you get married and then you get divorced, a divorce is a lawsuit. If you have kids and your kid gets into trouble, that's a lawsuit. Okay. And then maybe you do something and you get in a dispute with someone and, you got a couple of those and that's a lawsuit. Maybe you have an insurance claim and your insurance company doesn't pay you and you got to sue them and that's a lawsuit.
Yep.
It's sort of easy to see 7 lawsuits actually.
Yep. And it's hard to pin down. What I always want to try and find is what are the odds of you actually getting sued in general, right? And there's some statistic on the medical, because the American Medical Association keeps some stats, and it's like 1 in 3 doctors will get sued at some point in their lifetime. But I'm pretty sure it's pretty safe. If you're a business owner or you're a real estate investor, you probably have somewhere around 1 in 4, or maybe even 1 in 5 chance of getting sued in general. I mean, because again, the lawsuits may have been something that you instigated, but I'm talking about somebody suing you.
Yeah.
The chances are pretty, it's not crazy, 1 in a million. It's going to be a 1 in 3 or a 1 in 4 chance of you getting sued.
Yeah. But the misleading thing about that statement, which is a statement everybody makes, is that it's not about you getting sued. Sometimes you have to be the plaintiff, right?
Correct.
Because someone takes advantage of you and you got to go pursue it, right? But if that case doesn't work out, your attorney might end up suing you for fees, because attorney fees are beyond absurd, right? That might happen. Or you might lose and they get a judgment against you for attorney's fees. So you don't have to get sued to have problems, okay? And that's why you got to do this.
And we are working on that. I know there's only 1.3 million lawyers in the U.S., Jason, but we are trying to get the supply of lawyers higher and higher so we can keep those fees down. So I know there's a bunch of lawyers coming through the law school system, and maybe that'll reduce the legal fees because of the supply and demand dynamics.
It doesn't seem to. The problem with being an attorney is there's no scalability to it. And so attorneys have to charge really high hourly rates because they're only one person. And once they've sold their time,
that's right. They're like hotel rooms. Once the hotel room that night comes and goes, we can't resell last night's hotel room.
Yeah, exactly.
Yeah.
Exactly. Well, Mauricio, this has been a fascinating conversation. Thank you for sharing your wisdom with people. Where can they find you?
They can go to legalstrategiesforeveryone.com. I've got a website there and it's on Amazon, but that's probably the easiest way. And if you need to get a hold of me, just go to askmauricio.com, and that'll point you in the right direction.
Sounds good. Mauricio, thank you so much for joining us.
Thanks for having me, Jason. Really appreciate it.